Assalamualaikum warahmatullahi wabarakatuh. We are going to present on the topic Iqra, Rayu Al-Qabir, and Qarina. Here are the questions. Abdul Wahab and Abdul Wahub were charged for committing murder. Abdul Wahab, during the trial, confessed that he committed the offense charged. He also stated that Abdul Wahab has assisted him in the commission of the crime. Abdul Wahab denied the fact. The prosecutor tendered the evidence of an expert, Mr. Kangkung, who testified that the knife which was found on the deceased body has the fingerprint of Abdul Wahab and Abdul Wahab. He also disclosed that the blood stain on Abdul Wahab's shirt is of the same group as the deceased blood group. Abdul Wahab denied this, saying that on that day, he met with a minor accident as a result of which he has bleeding nose. Suppose the prosecutor tenders another expert opinion, which later appears to be contrary to Mr. Kangkung's opinion.
The first issue in this case is whether the confession made by Abdul Wahab is admissible. Based on Article 1752 Major, it is for someone to admit right of another against himself, but according to Section 17 Clause 1 Sharia Court Evidence stated that an admission made by a person in writing or orally or by gesture stating that he is under an obligation or liability to another person in respect of some right. Al-Iqrar is a form of admission for proving a fact in order to establish a right of another person against the maker of the confession made. Allah has stated in Surah Al-A'raf verse 172, remember when Yahweh brought forth from the children of Adam, from their loins and their seed, or from Adam's loins his offspring, and made them testify as to themselves, saying, am I not your Lord? They say, yes, please testify. Yes, you should say on the day of resurrection. Very likely had been unaware of this. While based on a hadith narrated from Ma'is bin Malik, Abu Hurairah reported a person came to see the Prophet ﷺ when he, the Prophet himself, in the books and said, O the Messenger of Allah, I have committed adultery. The Prophet turned away, and after that person had testified four times against himself. The Prophet called him and said, are you mad? He replied, no. The Prophet then said, take him and stone him. This is a hadith based on a case of adultery. But a person who wants to make an admission must fulfill all the requirements first in order to be a qualified muqarrun. There is the rukun of muqarrun. The rukun of al-iqrar is first, muqarrun is the person who makes iqrar. Second, muqarrun lahu is the person who receives benefit from iqrar. Third, muqarrun bihi is the subject matter of iqrar. And four, sirah, the words indicating the admission. While the condition of muqarrun is first, sound mind and has attained the age of majority. Iqrar made by a minor and intoxicated person cannot be considered as valid. Second, must not be lunatic or mentally retarded. Third, must not be made by wali or guardian on behalf of person under custody. And lastly, must be made voluntarily or free consent was given with full aware the effect of the admission he made. In this case, it can be applied that Abdul Wahab and Abdul Wahab were charged for committing murder. Abdul Wahab during the trial confessed he committed the offense charged. This means the consent has freely given as he made voluntarily without being forced by any other parties. He also stated that Abdul Wahab had assisted him in the commission of the crime. Since Abdul Wahab has fulfilled all the elements and conditions in order to make iqrar as a valid, the admission can be regarded as a valid iqrar. In conclusion of the above situation, Abdul Wahab is charged for committing the murder since he is voluntarily made an admission.
The second issue that needs to be decided in the present case is whether Abdul Wahab's confessional statement of the commission of murder will have an effect on Abdul Wahab. The law provided in the case mentioned above is Article 78 of Majal, which stated that while admission is approved, which is restricted in its effect, while Article 79 of Majal also stated that by admission a person is bound, making iqrar having a restrictive effect only on the maker. This can be followed by the case of Halimah against pendakwa Jenayah Kelantan. In this case, it can be applied that Abdul Wahab during the trial confessed that he committed the offence charged, but he also said that Abdul Wahab assisted him during the offence. However, Abdul Wahab denied the fact. Since the QICs do not admit the offence charge against him, he will not receive restrictive effect on him. Thus, if only binding on Abdul Wahab, since one admission is sufficient enough to charge the offence, Abdul Wahab may get punished as admission he made is valid. To summarize, the admission made by Abdul Wahab is valid and he is convicted. However, Abdul Wahab is acquitted since he didn't admit the offence.
The third issue in this case is whether Mr. Kangkung, the expert evidence, reached the level of strong qarina. Al-qarina literally means together, accompany, related, or anything which explains or shows something. According to Abdul Karim Zaidan, al-qarina is anything which may be used as proof to establish the existence or non-existence of a thing. The four Sunni schools have accepted qarina as a method of proof based on the following authorities of Surah Yusuf verse 18. Destin he shared with falsehood. He, Prophet Yaqub, said, Nay, but your minds have made up a tale. Let me pass with you. For me, patience is most fitting. Yaqub has treated the bold stand shirt as an evidence showing that Yusuf is still alive, since the blood-stained shirt was not torn as it should have been if Yusuf was really attacked by wolf. Yaqub was narrated to have said, When did wolves become so clever that they could eat Yusuf without tearing his shirt? Regarding the standard of proof for the admissibility of al-qarina, not all qarina have the same quality and value in evidence. They are strong and weak qarina. Only strong qarina will be accepted, while the weak and unconvincing qarina will be rejected. Strong qarina is the one that makes a fact established or shows a convincing indication, and the conclusion made out of it is unrebuttable. According to Abdul Munim al-Bahai, the qarina which will be taken into consideration is the one which is strong, in the sense that it can be used as a basis of deciding a matter. Article 1741 stated, A complete presumptive proof is an inference which attains the degree of positive knowledge. By this article, it is understood that a qarina must reach the standard of yaqeen. However, the jurists are of the opinion that the standard of yaqeen here does not mean beyond any shadow of doubt. It only needs to reach al-zan al-ghalibah, because as a presumptive evidence, no matter how strong qarina is, it still carries doubts. Thus, to be admitted, the qarina must at least attain the standard of al-zan al-ghalibah. Abdul Wahab and Abdul Wahab were charged for committing murder. The prosecutor tendered the evidence of an expert, Mr. Kangkung, who testified that the knife which was found on the deceased body has the fingerprint of Abdul Wahab and Abdul Wahab. He also disclosed that the blood stain on Abdul Wahab's shirt is of the same group as the deceased blood group. Abdul Wahab, however, denied this, saying that he had a minor accident which caused him having nosebleed at the time of the commission of the murder. But Mr. Kangkung's opinion shows a convincing indication, and the conclusion made out of it is unrebuttable, that make his opinion reach the level of al-zan al-ghalibah. The conclusion is Mr. Kangkung's opinion reached the level of strong qarina.
The last issue is whether the evidence by Mr. Kangkung as an expert is sufficient to convict Abdul Wahab for the offence of murder. Ra'yu al-Kabir can be defined as a testimony of a person specially skilled in a certain field. For example, opinion of DNA expert on the paternity of a child. According to Section 33 of the Sharia Court Evidence 1997, when the court has to form an opinion upon a point of foreign law or a science of art, or as to identity or genuineness of handwriting or finger impression, or relating to determination of nasab, the opinions upon that point of person specially skilled in that foreign law, science or art, or in question as to identity or genuineness of handwriting or finger impression, or relating to determination of nasab are qarina. Such person are called expert. For application of expert opinion both in criminal and civil cases, opinion of doctor may be needed to prove the cause of in murder cases or type of injuries, to quantify suitable amount of compensation, two or more experts can be called to give evidence where possible, but if two experts are not available, the evidence of one expert is sufficient. If two experts give conflicting opinion, the third expert shall be called to give evidence and shall write. Here means the third expert must be called. Allah is stated in the Holy Quran Surah An-Nahl verses 43. If you release this not, then ask those who possess the knowledge. Thus, judges who are facing perplexing issue should consult person who are such skilled in such issues. The rationality for admitting expert opinion is because the knowledge of judges is limited. The judges are not expert in all fields. Judges need clear information and understanding before giving decisions. Based on a case of pendakwa syar'i Negeri Sabah versus Rosli bin Abdul Jabbar. In this case, the Syariah High Court of Sabah in Keningau had convicted the accused for the offence of committing illegal sexual intercourse punishable with ta'zir, not punishable with hudud, under Section 80 Subsection 1 Syariah Criminal Offence Sabah Enactment 1995 based on the DNA finding that he is the biological father of a son born by a woman. The court observed that the DNA test conducted by expert amount to strong qarinah and it is for the accused to challenge the strong qarinah. However, that is the effect of expert opinion. Hanbali school say it binds the judge, so the judge must act upon the opinion of expert provided that the expert are trustworthy expert. The above is logic because the judge has no knowledge on the matter. The Hanbalis give an example where 4 witnesses testified against a woman for zina, and there are several trusted women experts testified that the woman is still virgin. Then, no had can be imposed on the woman since the opinion of expert woman had raised doubt, even though initially the judge is bound by the testimony of the 4 male witnesses. In this case, it can be applied that the prosecutor tender the evidence of an expert, Mr. Kangkong, who testified the knife which was found on the deceased body has the fingerprint of Abdul Wahab and Abdul Wahab. Under Section 33 of the SCE 97, expert opinion amounts to qarinah only. Thus, it does not bind the judge and its admissibility depends on the quality of the qarinah. If the qarinah is strong, then the judge should accept it. If it is weak and unreliable, then the judge should reject it. Moreover, Mr. Kangkong disclosed that the blood stain on the Abdul Wahab shirt is of the same group of the deceased blood group, but Abdul Wahab denied this, saying that he had a minor accident which caused him having nosebleed at the time of the commission of the murder. In this case, it needs 2 or more experts in order to convict the offence to both accused. The prosecutor tenders another expert opinion which later appear to be contrary to Mr. Kangkong's opinions. Hence, court need to call the third expert to confirm which of the opinion is accurate. In conclusion, Abdul Wahab may be convicted for the offence if the third expert can confirm that the fingerprint on the knife and the blood stain on his shirt is of the same to the deceased blood group.